Hello everyone, welcome to our discussion regarding Chapter 1, the fundamentals of dynamic business law. Actually, this is an introduction to really the entire course and law in general. It's going to be pretty brief and very broad brush, but let's get started. So, what is business law and how does business law relate to regular law? An analogy that I think about is my career working at Marathon Petroleum Corporation. And people would ask me, oh, do you practice corporate law? And I was a little bit perplexed by that because corporate law is not a specific thing that you necessarily study in law school. You might study how corporations are formed, and we're going to talk about that in this course. You might study contract law, those types of things. But corporate law for me was really doing anything that related to legal work that my client, the corporation, wanted me to do. So that could be contract law, that could be um, sales law, that could be regulatory law, um, all sorts of things. But there was a broad scope of things that fell within the realm of things that a corporation would need me to do for them. And so I was practicing corporate law, which really contained a lot of different areas of the law. But it probably wouldn't include domestic relations or divorce law. Same way with business law. Business law deals with types of things that a business or a corporation or an entity like that might need help with. So business law, however, is not going to include domestic relations or family law or divorce law or anything like that, but it can include a wide variety of things, and we're going to talk about a wide variety of things in this course. Let's just say that business law is a catch-all. It's related to commercial relationships. So that's probably a good enough definition for us right now, is that business law, as opposed to regular law, deals with or concerns itself with commercial relationships. Not family relationships, but commercial relationships. And again, as you can imagine, that's going to include a wide variety of matters. What purposes do laws serve? And our book talks about this, and I'm not going to talk about every one of those purposes that are laid out. One of those is providing order. So you can imagine if we didn't have laws and regulations to guide our behavior, it could be a very chaotic society. So laws provide order. I like this example here on this slide. This is from the Ohio Revised Code, and in this course we will be talking about, Bowling Green is located in Ohio. I was licensed to practice law in Ohio, so I'm going to talk a lot about Ohio law during this course, and so here's a section of the Ohio Revised Code. And this section says, each operator of an underground coal mine shall provide bathing facilities, clothing change rooms, and sanitary toilet facilities in a location at each mine convenient for the use of all mine employees. Bathing facilities, change rooms, and sanitary toilet facilities shall meet the following minimum requirements. And then that subsection H, an adequate supply of toilet paper shall be provided with each toilet. So there is a somewhat humorous example of a law providing order. Okay, so here is a section of the Ohio Revised Code which talks about mine operators needing to provide certain things. So it is providing order. Another purpose that laws serve, and I like this one from the book, and this gets into ethics, which we'll really talk about more in chapter 2, but laws serve as a moral guide for our behavior. Again, when we talk about ethics, we'll talk about the fact that yes, laws do serve as a moral guide, but they're not the only guide. In fact, we'll talk about the fact that laws are our minimum standards. They sort of set the floor for our ethical behavior. So again, I think one of the purposes that laws serve, and this is laid out in the book obviously, is a moral guide. It helps us make moral decisions. So let's talk about some other broad categories of the law. We've talked about business law versus regular law. Now let's talk about private law versus public law. So private law concerns law governing the disputes between persons or groups of persons. Here's an example. Let's say you slipped and fell in an establishment at Bowling Green, and you wanted to sue that establishment because you felt like they were responsible for your slip and falls and hence responsible for your injuries. You'd be suing them under a theory of tort law, and we're going to talk about tort law later in the course, but tort law would be considered private law. Okay, we'll say, well, wait a minute, we're talking about an establishment which would perhaps be a corporation. So would suing a corporation take it out of the realm of private law? And the answer to that is no. We're going to talk about that later, but under the law, corporations are deemed to be persons. So even suing a person under a theory of tort law would still keep it within the realm of private law. Now the difference is when the government gets involved, and here we're talking about public law. So an example would be the Clean Water Act. So if you had a pipeline leak and the Clean Water Act was involved, so that would be a situation where that is a law established by the government. Okay, so the government's involved, that would be an example of a public law. Now, civil law versus criminal law. And this is pretty evident on the face of things. I think you probably know the difference between civil law and criminal law. Let me give you a quote from the book. The book states that civil law is, quote, the body of law that governs the rights and responsibilities either between persons or between persons and their government, end quote. So again, it's governing these disputes between persons or between persons and the government. Now, I think one thing that might help us really understand civil law is what you're normally looking for by suing somebody or having a lawsuit that falls under civil law. You're probably looking for restoration, to be restored to the situation you were in before the incident occurred. Okay, so here you're probably looking for monetary damages. So remember that private law example I gave you, a slip and fall in Bowling Green? So that would be private law, but it'd also be civil law, because in this instance, it's a dispute between persons, okay? But you're not looking to put somebody in jail. You're looking for restoration. You're looking for monetary damages. You're looking to be made whole. Criminal law. Let's have a quote from the book again. Criminal law is, quote, the body of laws that involve the rights and responsibilities an individual has with respect to the public as a whole, end quote. So here we're talking about the general public being involved in a very broad way. So an example, let's say you at this establishment, but you were doing something else and you broke a window. Well, that breaking the window, and that wasn't an accident, you were intentionally trying to do that. So that breaking the window, yes, did it hurt the store owner? Yes, it did, and that would probably be civil law. But it also hurt society. That lawlessness hurt society or the public as a whole. So that would be an example of criminal law. And again, I like to think of what you're looking for under criminal law. You're looking for deterrence and punishment. You're not necessarily looking for that under civil law. Criminal law, you're looking for deterrence to stop future behavior like that through probably punishment. So again, private law versus public law, civil law versus criminal law. Again, civil law, according to the book, quote, the body of law that governs the rights and responsibilities either between persons or between persons and their government, end quote. Criminal law, quote, the body of laws that involve the rights and responsibilities an individual has with respect to the public as a whole, end quote. So here's an example of that interplay between civil law and criminal law. And that's the O.J. Simpson case. And you might remember reading about this case. I'm old enough to remember this case actually going on. And you recall O.J. Simpson was accused of murdering his wife and another individual, Nicole Brown Simpson and Ronald Goldman. And so in this situation, O.J. Simpson was found not guilty. I have this picture of a glove up here because you remember a famous line from that case is that if the glove doesn't fit, you must quit. And O.J. Simpson tried to try on the glove that was allegedly involved in the incident, and it would not fit. So based on that and other reasons, he was acquitted in the criminal trial. But you know what happened later? The families of Ronald Goldman and Nicole Brown Simpson sued O.J. Simpson, okay? And they sued him under civil law. And under civil law, they recovered, let me look at it here, read it, get it right, $33.5 million in damages. So there you see a case that fell under criminal law, but also fell under civil law. It fell under private law when the Goldmans sued, and the families of Ronald Goldman and Nicole Brown Simpson sued O.J. Simpson, private law. And public law was the criminal trial. So where do we get our business law from? Where does it come from? Well, it comes from a variety of sources. It comes from constitutions, okay? The U.S. Constitution, your state's constitution, comes from statutes, federal statutes, state statutes. And by the way, when we talk about constitutions and statutes, we're talking about something that's been written down, something that you can find easily in code books. We're going to call that enacted law. Okay, enacted law. That law has been enacted by a body. In the case of statutes, it's been enacted by the federal government or the state government. When we talk about constitutions, you could say it's been enacted by the people, but it's enacted law as opposed to cases or case law, or we would also call that common law, and that's law that is that it evolves over time through court decisions. Okay, and then we have administrative law, which really, to me, involves more minutia. It involves enacted law. It involves regulations. Here's you can see the citation I have here that talks about Ohio law. Ohio law consists of the Ohio Constitution, the Ohio Revised Code, and that's the statutes, and the Ohio Administrative Code, that's the regulations. The Constitution is the state's highest law, superseding all others. The Revised Code is the codified law of the state, while the Administrative Code is a compilation of administrative rules adopted by state agencies. Even if it wasn't state agencies, if you talked about the federal government, you talk about the EPA creating rules and regulations, and that would be administrative law. So again, sources, constitutions, statutes, cases, and administrative law. And what I read you also talks about a hierarchy, and we're going to talk about that in a little bit. Other sources of business law, we're not going to talk about these very much, but treaties and then executive orders. You might recall the executive orders have been in the news recently because President Biden, through an executive order, did away with some student loans or debt. And you'll also recall that that executive order was overturned, if you will, because another branch of the government, I believe the court system, ruled that he was outside of his authority in doing that. So again, executive orders. Let's talk about something that's a little strange of a word or phrase, stare decisis. And you can see from the slide there, that means to stand by things decided, stare decisis. And we talked about this hierarchy of the law. So when we talk about stare decisis, we're talking about how courts make rulings, and this really adds order to our system. So, for example, the Supreme Court, when the United States makes a decision, well, that's the highest governing authority when we talk about court rulings. And so lower courts are bound by the Supreme Court rulings. That's stare decisis, to stand by things decided. The Ohio Supreme Court. The Ohio Supreme Court has to follow the U.S. Supreme Court. What about the Court of Appeals? Ohio is divided up into several different courts of appeal districts. And you might recall from my bio that I worked for the 3rd District Court of Appeals. Well, if the Ohio Supreme Court makes a decision, then the 3rd District Court of Appeals has to follow that decision. What about a Court of Appeals versus another Court of Appeals in Ohio? Well, the 3rd District Court of Appeals doesn't have to follow the 4th District Court of Appeals. That might be persuasive authority, but they don't have to follow that. So this idea of hierarchy, a lower court needing to follow a higher court, really helps our system to be well ordered. Now, you can see there that I have these arrows, and we've really been talking vertically, although we talked about horizontally a little bit with regard to the 3rd District Court of Appeals and the 4th District Court of Appeals. But sometimes even a court will disagree with itself later on. You've seen that in the recent decision of that where Roe versus Wade was overturned. And there was an example of the Supreme Court overturning itself. And that can happen within a court. A court can say, in so many words, hey, you know, we've thought about this and we need to go in a different direction. And so a court within itself can go ahead and decide to rule in a different way than the way that they have ruled before. So stare decisis, okay, to stand by things decided. Again, generally a lower court's going to follow a higher court, and generally a court is going to follow decisions previously made by itself. Let's talk about schools of legal interpretation. So the book talks about these: identification with the vulnerable, the historical school, which is based on tradition, legal realism, cost-benefit analysis. I'm not going to talk really about those in any detail at all, but I did want to talk a little bit about something, again, you hear quite a bit about in the news. I did want to talk about one theory of interpretation, that is talked about in the book, and that's this idea of originalism. And originalism is also something you might have heard in the news recently. So, in talking about the Supreme Court, especially, um, you'll hear the news outlets talking about um, originalism with regard to Supreme Court, U.S. Supreme Court decisions. And in this instance, the court is trying to make a decision, the originalists on the court, the individuals on the court who subscribe to this theory, they're trying to make a decision based on what was the original intent of the framers of the Constitution. Okay, so they look from a very historical perspective, in very broad strokes. To originalists, the Constitution is not necessarily a living and breathing document that evolves over time, but the Constitution is more of a static document that you're trying to determine what was meant by the original framers of the Constitution. Okay, so that is originalism. So we're going to end our discussion of Chapter 1 here. Thank you for your attention, and we'll see you next time.